In this unit, we're going to cover the display of your dealer's license, also dealer ethics, license suspensions and denials, the disciplinary penalty matrix and the enforcement division, dealer complaints, dealer insurance, your retail contract bill of sale, odometer disclosure and tampering, sales to minors, dealer records and records inspections, and also the very important roles and responsibilities of the Texas Department of Motor Vehicle Board. Remember, all Texas dealer licenses must be displayed prominently. This is a state law. When you receive your used motor vehicle dealer's license, it must be displayed prominently. You do not place that license in a desk drawer or file cabinet. You need to place it on the wall in your office. You know, you've worked really hard to gain your license and you're going to be proud of it. So make sure and display it where everyone can see it. You know, if you ever do have a surprise inspection from Texas Department of Motor Vehicles enforcement personnel, they will verify that you have your license displayed conspicuously. And the new law that just went into effect also requires that you display your dealer surety bond information right next to your dealer's license as well. Dealer ethics and integrity. It is imperative that you operate your new business with complete integrity and the highest ethical standards at all times. You must follow every state and federal guideline on every transaction, period. If you don't operate strictly under all state and federal regulations, your dealer's license could result in suspension or revocation. Once you've had a dealer's license revoked, it is time-consuming and can be very costly when you have legal fees for legal representation in order to obtain another dealer license. Being completely honest with every one of your customers is a win-win situation. And you're really going to build your reputation your first few weeks in business, and you must build an ethical reputation. A good, positive selling experience with the customer will lead to many more sales to that customer's friends, their coworkers, and their family. A bad, negative selling experience will result in customers leaving negative reviews of your dealership all over the internet. It's very easy for your customer to leave negative reviews and comments on Google and Facebook and Twitter and even more. You know, when future customers see these reviews, they will not purchase vehicles from you. Customers want a dealer they can trust. To maintain your honest reputation, you must offer full disclosure on all vehicles before the sale. Always disclose every minor mechanical malfunction that you're aware of before the test drive. By disclosing everything you know about a vehicle before the test drive, you're going to build this incredible reputation in your area with your new business. Unethical dealers can never discard a dishonest reputation. By operating your dealership with complete honesty and the highest ethical standards at all times, you will gain an honest reputation that will lead you to many more sales than that of a dishonest dealer. Being completely honest with your customers is absolutely imperative. You know, you're going to have the best reputation in your area. You're going to have hopefully the highest profits, and you're going to be in business for many, many years. Operating your dealership with complete integrity and 100% compliance equals more profits, while ensuring your dealer's license will never be suspended or revoked. Let's talk about reasons for suspension or revocation of a used motor vehicle dealer's license. You know, when you're granted a dealer's license, the state of Texas is giving you an opportunity to enter a business field that can be quite lucrative. However, you must follow several sets of rules and guidelines. All Texas motor vehicle dealers must follow the laws that we're discussing in this course, and the Texas Department of Motor Vehicles has zero tolerance for any dealer that does not follow the rules. Any dealer that does not comply or follow the rules can have their dealer's license suspended, revoked, and even pay extensive fines. Reasons for suspension or revocation of a Texas dealer's license. You know, if you're following along in the training manual that you downloaded at the beginning of the course, you can read these with me, okay? Falsifying or forging documents. A dealer may not falsify or forge a title document, including an affidavit making application for a certified copy of title. Filing a false or forged document. A dealer may never file false or forged tax documents as well. Keeping open titles. A dealer may not fail to make assignment of any basic evidence of ownership, including a certificate of title for the vehicle the dealer requires, which is called an open title. And we're going to cover this extensively later on in the course. Receiving, holding, or delivering an open title is a violation of the law, and it is also a very risky way to conduct business. An open title is kind of like a blank check. Not assigning titles. A dealer may not fail to assign any basic evidence of ownership, including a certificate of title for a vehicle that the dealer sells. Misuse of plates or temporary tags. A dealer may not use or permit the use of a metal dealer license plate or dealer's temporary tag on a vehicle that the dealer does not own or control, or that's not in stock or offered for sale. And we have a whole section later on how you can legally use your metal dealer plates and your temporary tags. Making material representations that are false on an application. If a person misrepresents a fact on an application to the Department of Motor Vehicles, whether it's a false statement of ownership or a false response to a felony question or a designation of false place of business, a serious violation has occurred. So you have to be completely honest when you're submitting that application through e-licensing and answer all questions correctly. Such violations could result at the very minimum in the denial of your dealer license application and can result in civil penalties. Failing to maintain qualifications for a GDN. The initial requirements to get your license must be maintained throughout the licensure period, and this includes all requirements as to signs, business hours, office requirements, phones, allotted spaces on your lot, leases, etc. The department may deny an application for a license or revoke or suspend a license, impose a civil penalty on a person whose license has been suspended, or reprimand a license for any of the reasons that are set forth in the Occupations Code. The Texas Transportation Code allows for a civil penalty of up to $1,000 for each act in violation and for each day of continuing violations of the Texas Transportation Code. The Texas Occupations Code also allows a civil penalty of up to $10,000 for each violation and for each day of a continuing violation of Chapter 2301 of the Texas Occupations Code or Section 503.038A, Texas Transportation Code Section 2301.801, or Texas Occupations Code also sets forth standards for assessing penalties. Civil penalties can range from $1,000 to $10,000 per violation per day. Remember, compliance is the name of the game in this new business. The department shall revoke a dealer's GDN if the dealer obtains the dealer number by submitting false or misleading information. Refusal to provide evidence of being in business. A dealer may not fail to provide the department within 30 days after the date of demand by the department satisfactory or reasonable evidence that the person is regularly and actively engaged in business as a wholesale or a retail dealer. Not remaining regularly and actively engaged in the business. Those people who are not really in the business as dealers normally carry a license for some other nefarious purpose. Maybe they just want to get a license to avoid paying sales tax for the vehicles they're driving, or possibly they want access to an auction to buy their vehicles at wholesale. Regardless, any person who makes fewer than 5 sales per year will have their license challenged. You have to make sure you're selling at least 5 vehicles per year. Texas law now requires a tax appraisal district to turn in to the MVD the names of any dealers who either fail to file the annual VIT declaration and monthly statements or do not sell 5 vehicles within the calendar year. Remember, wholesale transactions will count towards the required 5 sales. Failing to report or pay taxes. Although the MVD does not collect taxes, those dealers who fail to properly report and pay sales tax or vehicle inventory taxes could result in additional penalties and revocation of licenses from the agency. Misuse of license. Misuse of a license involves any use of the license for a purpose other than that which is specifically contemplated under the state and federal dealer laws. Lending license numbers to an unlicensed entity to buy or sell vehicles, you can't do that. Or using the dealer location for illegal purposes. These are examples of misuse of a license. Off-site sales or curb stoning. Dealers are not allowed to sell vehicles from anywhere but their duly licensed premises. And this is according to 43 Texas Administration Code, Chapter 215.186. Dealers are strictly prohibited from curb stoning, which is the practice of selling vehicles away from your licensed location. Dealers are also subject to penalty if they aid and abet curb stoning by selling vehicles to persons who practice curb stoning. So remember, you can never have retail sales activity away from your licensed location. Failure to apply for a title within 30 calendar days of the date of the sale, or 45 days if offering financing, or 60 days if sold to a military purchaser. The most common complaint received from consumers is they have not received their plates or title to the vehicle within 30 calendar days of the purchase. There are really only two valid defenses to this violation. The first defense is if the consumer has misrepresented their credit history on the credit application, and in that instance, the dealer has the right to rescind the contract. The second defense is if the dealer has promptly paid off the lien holder and the vehicle, but the lien holder has failed to issue a release of lien within 10 days of the payoff. And this is known as the lien holder excuse. So a seller finance sale has 45 calendar days to apply for the title. Dealers are exempt from transferring title for certain vehicles based on vehicle weight. Here's another violation: giving the title work to the customer. Since January of 1996, dealers are required to apply for the title and registration and never give that title paperwork to the consumer. It is your responsibility to title and register the vehicle that you have sold to your customer. The tax assessor collector offices have been very cooperative in turning in paperwork to the MVD that's been filed by a consumer who bought a vehicle by a dealer. Remember, that's not allowed. The only exception to that rule is if a consumer has taken the vehicle immediately out of the state, and then the dealer should have the consumer fill out the comptroller sales tax exemption certificate for those vehicles that are been taken out of the state. And always keep all these forms, including your comptroller sales tax exemption certificate, in your records in case you do get an audit. Just always remember that incomplete or no records are huge violations. So the rules require records to be kept at least 48 months. The current and immediately preceding 13 months must be available for inspection at the dealer's location. Records from the prior 35 months may be kept either on the license site or an off-site within the same county. Failing to keep records at all or incomplete records is a very serious violation. Not responding to requests for records. Not keeping records is a serious violation, but not producing those records when a representative appears at the dealership is even more serious. So most information is requested by the MVD through certified mail. If a dealer fails to respond to this mail request, it is a violation, and the agency representative may travel to your dealership to inspect not only the requested information, but the general state of records as well. So when the state requests records, make sure you get them to the state in a timely manner. Forgery or fraud, this encompasses odometer rollbacks, title fraud, or fraudulent sales of reconditioned vehicles. Also in this category are credit fraud or commercial fraud or floor planner fraud, where you're not correctly paying your floor plans, consignment fraud, and these usually go in hand with some other activities. So in all these instances, the perpetrator has made representations that have induced someone to buy a vehicle that he or she would have not have purchased, but for those fraudulent representations. Fraud is also cited when a dealer files a false tax document or title document. Spot deliveries. This fraudulent practice consists of selling and delivering a consumer a car after signing a retail installment contract and then calling the consumer back into the dealership to sign a new contract with higher interest, higher payments, or to put more money down. This practice happens a lot when a dealer wants to tie the consumer to a sale but is unable to verify the credit in a timely manner. Dehorsing. Dehorsing is done in conjunction with a spot delivery and occurs when the consumer refuses to sign a new contract and demands back their trade-in, and then they're told the trade-in has already been sold, thus forcing him or her into the new contract or a vehicle for lesser value. That's called dehorsing. Parking on the right-of-way. Dealers are specifically prohibited from parking or displaying vehicles on the right-of-way adjacent to their dealership premises unless the government body has jurisdiction over that easement and has expressly consented to such use. And use of right-of-way property that is part of the state highway system could only be authorized through a lease agreement with the Texas Department of Motor Vehicles. Now, parking on the right-of-way, that permission is very seldom given to any dealer due to the nature of the safety hazard involved in allowing cars to obstruct the views of oncoming traffic. If a dealer wishes to inquire as to written permission for this process, then you need to contact your local Texas Department of Transportation office. Failing to settle civil penalties. One sure way to lose a license permanently is to refuse or neglect to settle any penalties that have been occurred against your dealership by the department. Odometer tampering. Dealers are strictly prohibited from fraudulently tampering with an odometer to reduce the number of miles indicated on that instrument. This is a federal and state law crime with serious criminal penalties. Besides the criminal penalties, a person could be permanently denied a dealer license upon such conviction. Does not maintain an established place of business. You have to maintain your business requirements during the entire time that you have your dealer's license. So you can't just close your doors and not operate your dealership. You have to maintain your established place of business during the entire time that you do have your dealer's license. Use of false or deceptive advertising. So we have a whole section on advertising later on. Fail to notify the Texas Department of Motor Vehicles Motor Vehicle Division of license entity changes within 10 days. Or, fail to notify the Texas Department of Motor Vehicles of any ownership changes within 10 days. Or any address changes within 10 days. Also, you can never fail to maintain your $50,000 dealer surety bond your entire dealer license year period. Dealers must remain bonded your entire time that you have a dealer's license. So you must maintain that $50,000 dealer surety bond the entire time that you have your dealer's license. Here's another violation. Failure to file annual vehicle inventory tax. Failure to file monthly tax, failure to sell 5 vehicles per year, premises violations, that includes bond violations, filing false tax statements when transferring titles. What's filing false tax statements? Well, let's say, for example, a dealer sells a vehicle to a customer for $4,000, but when you're doing the title transfer, you say that you sold it for $2,000. That's a big no-no, and you could have customers ask you to illegally do that. So always make sure that you put the correct sales price on all paperwork that you are submitting to the state. Reasons for denial of a Texas application for dealer's license. So how can you get a dealer's license application denied? False statements of material facts on the application, so you have to be completely correct on your application. Criminal history specified in Texas Administrative Code 211.3 or specified in the Texas Occupations Code 53.021. If you've got no established place of business, you can't have a dealership. If you don't have a working telephone, you can't get your dealer's license. Or if you don't have a display area, or if your display lot is not physically separated from other businesses' parking. Business is not physically separated from another business. So just always remember, dealers must follow every law, rule, and guideline in order to operate a successful and profitable dealership. Any dealer that does not operate completely within the law will face fines and or license suspension or revocation. Next, I want to talk about the disciplinary penalty matrix. Texas dealers that do not follow every law, rule, and guideline may face substantial penalties, okay? So Section 503.095 of the Texas Transportation Code allows for a civil penalty of up to $1,000 for each act in violation and for each day of continuing violations. The Texas Occupations Code allows for penalties of up to $10,000 per violation per day for continuing violations of these codes. So I want you to be very aware that not following all the real rules and guidelines can be extremely expensive. The state may revoke a license for any violation according to the penalty matrix. The Texas Department of Motor Vehicles penalty matrix is basically sets the fines for certain violations of state law, and they're set into the matrix, and they're also written into the Texas Administrative Code. It clearly states the punishment for Texas motor vehicle dealers that violate the law. The low sanction of the disciplinary penalty matrix will set the minimum fines and punishment, and the high sanction will normally set the maximum fine or punishment. Depending on the circumstances for a specific case, the minimum or maximum penalties and fines can be changed dependent upon the severity and the number of violations. The matrix does not contain all possible violations, nor does it limit the Department of Motor Vehicles from seeking sanctions outside the disciplinary matrix recommended low and high sanctions when circumstances require. So here you see the Texas Department of Motor Vehicles dealer penalty matrix. As you can see here, if you willfully defraud a customer, the fine starts at $1,000 and can lead to revocation of the license. Falsification or forgery of tax documents starts at a $1,000 fine and can lead to revocation. And the federal fines for this could be much, much more. So be advised, we are only looking at state sanctions here, which would be in addition to any federal penalties. Let's look at some more here. Misrepresenting mileage starts at $2,000 and leads to revocation. Federal penalties could also include prison time for odometer crimes. Filing false VIT statements starts at $1,000 and can lead to license revocation. Let's look at some more violations here. Allowing someone to use your GDN, allowing someone to use your dealer's license carries fines of $500 to $4,000. You can never let unlicensed persons act as the dealer with your dealer's license. Take a look at this one towards the bottom. Acting as a manufacturer or distributor will lead to fines that start at $5,000 and can lead to charges being filed by the Attorney General's office. So these are some very, very serious violations. Take a look at a couple of more here. Violation of the blue law can lead to fines of up to $2,000. Selling or leasing a vehicle that does not meet emissions can lead to fines of up to $4,000. Overcharging documentary fees can lead to fines of up to $2,000. And I'll show you how to comply with the documentary fee laws later on in your course. So you want to make sure that you're never overcharging for that fee. If you follow every rule, law, and guideline required for your new business, you will never pay any fines and you'll always keep your license. Remember, 100% compliance equals 100% profit. So you take the initial steps to maintain 100% compliance. Hopefully you'll never pay any fines and you'll be able to keep all your profits. So remember, 100% compliance equals 100% profits. Next, I want to talk about the Texas Department of Motor Vehicles Enforcement Division. Texas laws are enforced by the Texas Department of Motor Vehicles Enforcement Division, and they actually receive about 12,000 complaints a year. So they investigate limit law violations and they also respond to dealer complaints. The Enforcement Division receives about 1,000 complaints each month, and enforcement investigators make contact with dealers and complainants to collect information based on complaints that are received. Investigators also assist law enforcement by training officers and other agents on rules and regulations that apply to dealer licensing. The Enforcement Division is made up of 5 sections under the direction of a single director who reports to the Texas Department of Motor Vehicles executive director. And so those 5 sections are administrative, legal, limit law, motor vehicle investigations, and motor carrier investigations. The legal section employs attorneys that review, investigate, and if needed, prosecute violations. Administration supports the other sections with the functions of human resources and accounting. The limit law section administrates the Texas limit law and warranty compliance programs that mainly affect franchise dealers that sell new motor vehicles. And then they have motor vehicle investigations and motor carrier investigations that are carried out as well. Dealer complaints. The Texas Department of Motor Vehicles makes it very easy to log a complaint against any Texas motor vehicle dealer. And they have several phone numbers and email addresses and online dealer complaint forms that can be completed at the Texas Department of Motor Vehicles website. As you can see here, it is very easy for your customers to log a complaint against your dealership. They can use this online form that you see right here and easily make an official complaint against your dealership.